All right, so we're going to be at 9:30. I'm going to again open up the committee to study medical intervention and immunizations. We're going to again start with the Pledge of Allegiance. The flag's over there. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So one of the things that I want to bring attention as we start this meeting is to make everybody, so everyone's on the same page. There are 33 LSRs filed relative to 4 topics, relative to COVID, masks, mandates, or vaccinations. I'm going to run through a quick list. It's a little boring, but I'm going to just run a list of the titles of those bills so people are aware of what bills are potentially upcoming, and it may relate or not relate to your testimony. So I'm just running these down in numerical order as I searched them on the General Court website. The first bill title is relative to requiring COVID-19 vaccination for school attendance, requiring the New Hampshire Attorney General to empower a COVID-19 grand jury to investigate the events related to the COVID-19 pandemic, relative to state grants for research into the effects on the human body of the COVID-19 vaccines, eliminating, never mind, scratch that one, requiring post-secondary institutions to accept religious and medical exemptions from vaccine requirements, requiring an audit of the New Hampshire Vaccine Association, making a state vaccine registry an opt-in program, relative to the exemptions from vaccine mandates, relative to the exemption from school vaccine mandates, relative to student attendance in public schools that mandate the wearing of face masks without an emergency order in place, limiting the authority of the Department of Health and Human Services to mandate vaccinations and relative to quarantine costs, relative to state enforcement of federal vaccine mandates, relative to the medical mandates adopted by employees, relative to employee protections from COVID-19 in the workplace, prohibiting the state and local governments from adopting certain mandates in response to COVID-19, and prohibiting employers and places of public accommodations from discriminating on the basis of vaccine status, relative to procedure of withdrawing from the vaccine registry, requiring the Department of Health and Human Services to maintain certain records relative to the vaccine registry, expanding the prohibition against discrimination based on the individual's election not to participate in the state vaccine registry, prohibiting the Department of Health and Human Services from requiring vaccine passports for services, prohibiting higher education institutions from receiving state funds from requiring face masks and COVID-19 vaccines for attendance, proclaiming Monday, the first Monday of March as the COVID-19 Victims and Survivors Memorial Day, relative to the limited liability for personal injury resulting or related to exposure from COVID-19, relative to unemployment benefits for employees terminated for refusing to comply with vaccine mandates, relative to the unenforceability of non-compete agreements upon termination of an employee for non-compliance with a vaccine mandate, relative to vaccine mandates and government contractors, relative to financial responsibility for employer-mandated COVID-19 testing of employees, prohibiting a school district from mandating COVID vaccinations for school attendance, prohibiting certain employees from requiring COVID vaccination as a condition of employment, relative to the eligibility of workers' compensation for adverse reaction to a mandatory COVID-19 vaccination, requiring Food and Drug Administration approval of all vaccines, relative to COVID-19 health and safety policies at New Hampshire performing arts venues, relative to the school district policies on facial masks for students in schools, requiring an independent audit and assessment regarding COVID-19 preparedness at long-term care facilities, nursing homes, and New Hampshire Veterans Home, and making an appropriation therefore. So those are, on my quick search, all the bills that we have that are currently going to be heard in the legislature. The goal of this committee is not necessarily to evaluate any of those bills. However, what we're looking for is the intersection of shall and shall nots in either state law or agency rules as it relates to medical intervention immunizations. So as a former police officer, I know there are certain roles of government that are appropriate. So and medical intervention is appropriate. So as a former police officer, I use the idea of an IEA, right? So there are times when a person's suicidal and this police mandate that they commit them to get treatment to make sure they don't hurt themselves. So we use the fire department with Narcan in an overdose situation. We can use an inmate in the prison who gets stabbed and is refusing medical attention. Extra enforced medical care. We're going to stitch that inmate up. So we know that there are certain roles of government that are appropriate and where medical intervention is appropriate in given circumstances. The problem is I'm not omnipotent and the committee's not omnipotent. We don't know where all of those intersections are. And the goal for this meeting is to bring out some of that information so the committee can evaluate those intersections in state law or agency rules. To see if they're appropriate, see if they need strengthening, or maybe they need to be weakened, or maybe nothing needs to be done with them. So that's the kind of thing I think the committee's looking for, and I'll open it up to committee members if they want to make any other comment before we start taking information from the people. Anybody? Erica, you're good? Erica Leon is here. She's replacing Herschel Nunez, who was unable to attend. Great. All right. First up, Erica, who do we got?
First up, we have Ann Edwards from the Attorney General's office.
I'm Ann Edwards from the Attorney General's office. I'm really here more to answer questions, and you might want me to answer questions after some of the agencies speak, since they're the ones who know their own statutes better. In looking at the invitation that was provided to the group, there were some specific questions. I can't answer all the questions of where the shalls and the shall nots are. I'd be happy to talk them through. Clearly, as you just said, Representative Lang, if there are shalls in the law, we have to follow them for the most part. Oftentimes in those same statutes, there are some exceptions, or there is case law that has developed exceptions to those shalls. And if there are shall nots, we have to follow those as well. And it's the same provisions that are available sometimes to modify what that shall not means in certain circumstances. With respect to the question of the definition of medical intervention, interestingly, that phrase itself shows up once in New Hampshire law, and it shows up in the statute RSA 415-D:3, which is the definition section of the Long-Term Care Insurance Act.
Could you repeat that RSA?
Sure. It's RSA 415-D:3.
Thank you.
And then the specific provision is Roman 5 in the middle of a very long paragraph that defines long-term care insurance. And in that statute, it provides that with regard to life insurance, this term does not include life insurance policies that accelerate the death benefit, specifically for one or more of the qualifying events of terminal illness, medical conditions requiring extraordinary medical intervention, or permanent institutional confinement, and that provide the option of a lump sum payment for those benefits. So that's the only place in New Hampshire law where the phrase exists. As a result, if this committee would like to suggest a definition of the term medical intervention, I think the path is wide open for you to do that. So in the law, when we are looking for how to define a term or how to define a phrase, and the courts are looking at that, we all go to the dictionary. And so one of the places to regularly start with that is the Merriam-Webster dictionary, which is where I proceeded. And they do not have the specific phrase medical intervention as a definition there. They do have the phrase, the word intervention, and that word is defined as the act or fact of taking action about something in order to have an effect on its outcome. And they further, in the online version, go into an explanation of medical intervention as the act or fact or a means of interfering with the outcome or course, especially of a condition or process, as to prevent harm or improve functioning. And so then they start talking about using specific examples such as mitral valve replacement in order to deal with a condition. So and then when you look at other definitions, I went to places like the National Institutes of Health, under the National Cancer Institute. Under that definition, in medicine, intervention is a treatment, procedure, or other action taken to prevent or treat disease or to improve health in other ways. And then there are many more medical dictionaries out there. One of the broadest definitions that I found was that intervention in medicine means anything meant to change the course of events for a person. Surgery, a drug, a test, a treatment, counseling, and providing informational pamphlets. So that's about the broadest definition that I could find. And so I think what that shows you is how you define the term medical intervention in New Hampshire law will be what it applies to. The one challenge with defining that term too broadly is to make sure that you're not sort of catching provisions of the law that you don't mean to interfere with by preventing in a certain way. And so when you look at House Bill 220 on starting on line 10, which is the shall not provision of House Bill 220 and all the things that House Bill 220 doesn't implement, many of these are those provisions that we would suggest that you be cautious of and aware of in defining medical intervention. The first is the Commissioner of Health and Human Services' ability to order quarantines and to order treatment for communicable diseases. The second is the requirements under current New Hampshire law for vaccination prior to admission to school or childcare agencies. The third is the involuntary emergency admission process and the involuntary treatment of patients. The fourth is to not limit treatment authorized by guardians or surrogates or individuals who hold a durable power of attorney. The fifth is that it doesn't apply to nursing homes, the state hospital, or any other medical facility operated by the state or by one of the political subdivisions. And then in the next Roman numeral section, it also excludes the Department of Corrections for any medical treatment or immunization that's required there. So those are some of the specific areas. Depending on how broadly you define the term, you could find that you also come into situations where there are mandatory examinations before an individual can hold a job. So for example, airline pilots have to have an examination. Commercial truck drivers also have to have examinations. Police officers have to have health examinations and have to do physical fitness tests. So there are those types of provisions that you want to be aware of as to whether or not you want to include those in such a definition. The other question had to do with informed consent. And in that area, I ended up in the American Medical Association's ethics treatises and read a fair amount about informed consent. And New Hampshire law also has requirements regarding informed consent. And informed consent is the process where communication between a patient and a doctor result in the patient understanding a treatment, understanding the possible positive and negative outcomes in conjunction with this condition that the patient has. They understand what the specific medical intervention is and what will occur during that procedure that is necessary. They understand any of the options for payment and for aftercare requirements, and that this informed consent conversation occurs so that the doctor is comfortable that the patient understands all of these provisions, and the patient is then able to make an informed decision based on the information the patient has received, and all of that needs to be documented in the patient's medical records. The one exception to all of this is that in the case of an emergency, if the patient isn't available and no other individual who has the ability to make decisions for the patient is available, then the physicians can initiate treatment without informed consent. And essentially, informed consent needs to be given after the fact by a full explanation of what the treatment was and why the decision was made as it was and what other opportunities or treatments are available from there. I believe those respond to the specific questions that came out in the invitation. So I'm more than happy to answer any other questions that I can. And as I said, I'll remain during the hearing. So in case there's something that comes up that you'd like to ask me afterwards.
Thank you. Thank you very much. Is there any questions from the committee? Representative Leon?
Thank you, Mr. Chair. Thank you for being here.
Put your mic up so they can hear.
Thank you. I'm not good at these microphones. Thank you for being here and answering these questions. When you're speaking to the emergency and when a patient can't consent, we actually worked through the advance directive change in the law last year. Are the doctors able to override a patient if they are saying that they do not want the treatment? And where's that line?
So that's a really difficult question to answer. It really is fact-based on what the situation is. And if the patient says no and the patient is mentally able to make that decision, then the doctors don't override those decisions because a patient can choose to not accept treatment if a patient wants to do so. The challenge becomes whether or not the patient's cognitive functions are impaired during that time period, either because they're ill or because they're injured or for some other reason, such as a substance use challenge. And in those cases, then there, depending on what the documents are, there's usually a secondary person who can make decisions for a patient who is not able to make decisions on their own, and that person will be contacted.
Thank you.
You're welcome.
Representative Goldie?
Thank you, Mr. Chair. What happens if a law is put in place that conflicts with federal law?
That's an excellent question. If it's a duly enacted federal law and it applies to all of the states, then the state of New Hampshire is most likely required to follow that law unless there's a challenge to that law. And so as a result, part of what you're seeing right now with respect to different rules, such as the OSHA rule requiring individuals requiring employers of more than 100 employees to have vaccinations or have a testing protocol, the state attorneys general in different states are challenging that law in that rule. And the reason for that is because when those rules go into place, as long as they're duly enacted correctly, they are valid laws. Whether or not the content of the law is constitutional or not is a different question as to whether or not it's a duly enacted law. And if it's a duly enacted law, then we're required to follow that federal law if it applies to us.
Can I have a follow-up to that, Jeff, for a second? I just want to make sure. We're talking about basically the Supremacy Clause, right, in the Constitution that says that federal law trumps state law.
Yes.
And I think to one of Representative Goldie's points is we're dealing with not necessarily a federal law that was gone through the legislative process, but we're dealing with an executive order out of a single branch of government as compared to a state law that's gone through the legislative process and two branches of government in theory. And does the Supremacy Clause apply to executive orders?
So that's an excellent question. What I was speaking about specifically was the rule, which is different than the executive order that is going through the process under the federal government's system for enacting rules. With respect to the executive order, it's the same type of position. If the executive order is duly enacted, then we as a state, and it applies to us, we as a state are required to follow it unless we challenge it. That is the point of our third branch of government, and that's why we raise those challenges in court.
You have a follow-up, Jeff? So again, I think we've seen the Attorney General's office has signed on, but I can't remember whether that relative to the executive order or to the OSHA rule and challenging the OSHA rule. I don't recall.
So we have currently a letter outstanding that we issued with respect to the OSHA rule with, I think, 24 other attorneys general raising concerns about that. That rule has not come out of the committee yet. It hasn't been put in place. So as a result, that doesn't have a court action against it. The court action that we joined last week is with respect to the executive order and the requirement that federal contractors have to require their employees and additional employees who have contact with them. It's quite a broad group of people that are falling under that provision in the executive order. So we are challenging that. And we are challenging, one of the reasons we are challenging that at this point is it is now being implicated against state agencies. So the Business and Economic Affairs has received a notice, Vital Statistics has received a notice regarding it. And so we now have a basis for being able to challenge that for our state agencies.
One follow-up question. So if the legislature enacted a law, does that make the AG's office case stronger or weaker? If we enacted a law that had to deal with mandates and federal mandates that have to be duly acted laws versus rules or regulations, or I should say rules or exemption or executive orders, does that help the Attorney General's office?
So these lawsuits are going to be in federal court, and the federal court looks at state law and certainly would look at a duly enacted state law as the intent of the state of New Hampshire, but that state law wouldn't necessarily override a federal executive order or specifically a federal law. That would be something that the court would take into consideration as an interest that the state is showing as an official position, but it doesn't mean that it would overrule it, even with the executive order, if the executive order was duly enacted.
Thank you. I have one more if nobody else says anything. So I'm going to go back to the informed consent conversation. Is the assumption in an informed consent conversation that the consent is given freely and voluntarily without coercion or threat?
Yes.
Thank you.
Thank you. And I have one other question from the legislation from Senate Bill 74 last year. There is language there that says that recognizing this right, which is the right to make your healthcare decisions and to refuse healthcare treatments, the refusal of healthcare treatments is not sufficient to demonstrate that a person lacks capacity to make healthcare decisions. So
Yes.
no concerns there.
No concerns at all. I mean, that is the state of New Hampshire state law, and I would argue that's the state of federal law. People can choose not to accept treatment.
Okay. And that same bill also said that if somebody's refusal then leads to a declaration of incompetence, that it protects the fact that they've refused this and this started the cascade in order to have a higher burden. Actually, if there's any other questions, let me get that exact language. Okay. I apologize.
I'll ask one more while she's looking up her language. So I'm going to go back to HB 220, and then in all open fairness, we've had conversations around HB 220 before, as I was the prime sponsor of that bill. Relative to HB 220, is it your interpretation of that law that it only applies to the COVID vaccine, or does it apply to all vaccinations and immunizations?
So it's the Attorney General's interpretation of that law that it only applies to COVID vaccines.
Thank you.
I think that answered my question enough. Thank you.
Thank you. You're all set, Ann. Thank you for
very
coming.
much.
Next up is DHHS. I think Beth Daly is here.
Good morning. I'm Beth Daly, the Bureau Chief for Infectious Disease Control at the New Hampshire Department of Health and Human Services. I'm joined today.
Hi, good morning. Melissa St. Cyr, I'm the Chief Legal Officer for the Department of Health and Human Services. And I understand that there were some questions for DHHS to answer related to the definition of medical intervention. Currently, the department does not have a definition for medical intervention. That term does not exist in RSA 141C, which is our communicable disease statute. And so we don't have that term in our statute nor in our rules. Certainly there are interventions, I guess you could say, that the department conducts, things under 141C, including isolation and quarantine orders, required treatment for those who are at risk to spread a communicable disease, and other things that I'm sure Beth could speak to a little bit more. Certainly we're here to answer any questions and are happy to provide any information that the committee would like.
Great. So, yeah, and I'll just add a little bit more detail about 141C and what the department, where we have shalls. So there is a requirement for certain vaccinations for child and childcare and school entry. Those are under 141C 20A. There are 2 permitted exemptions whereby parents can not have their child vaccinated and they can still choose to go to school or still attend school or childcare. And those are for medical reasons, if someone can't medically be vaccinated, or for religious beliefs. And then there's a notarized form that they can fill out for that purpose and present to the school so that the child can be allowed. In terms of that's really the only shall, I think, for medical intervention in this section. That applies routinely. We do have the authority to issue orders for treatment, which is quite uncommon for us to do. The disease that we do the most, have done that most frequently for, is tuberculosis. So in our state, if someone is diagnosed with tuberculosis, which can be a deadly condition and globally is a leading cause of death, we do compel them to receive antibiotic treatment so that they're not out in the community potentially infecting other individuals. Obviously, the vast majority of people want to take this treatment freely, and usually when presented with an order, they do comply with the treatment, and we've not had someone, there is a due process outlined for them in the statute, and we've not had people take that course of action to object to the order. And it's usually just a matter of them understanding the importance of the treatment. So that's it, I think, in terms of shalls. I did, just to piggyback on to what Ann Edwards had said about requirements for medical intervention for employment. I just wanted to mention it's not from DHHS, or it's not a state requirement, but there are some jobs that require vaccinations as well. And one particular one I just wanted to highlight for you was rabies vaccine. So if you work in a veterinary office, or if you work in a laboratory that processes rabies specimens, because it's a 100% fatal disease, there's only one person that we know of that survived that disease, they do require rabies vaccine as well. So again, that's another thing you might want to consider as you look at the scope of your work here.
That's it? You good? Questions for DHHS?
Thank you, Mr. Chair, and thank you both for being here today. When you speak to the orders that can be issued by DHHS, do those need to be individual orders, or could those be blanket orders?
No, they're individual orders pertaining to a specific individual. We've issued them for isolation and quarantine, and then the treatment ones that I mentioned as well, and they pertain to a specific individual. And we have a reason for a justification for that order. Do you want to chime in?
Yeah, no, that's exactly right. And so when an individual is issued an order, they obviously have the opportunity to comply with the order, or there's also the due process that Beth mentioned earlier, that they can appeal that and go and so it has to apply to the individual so that they can go through that due process rights type of hearing if they so choose.
Can you speak into the microphone? I'm just got a comment online that they can't hear you when you're speaking.
Happy to do so.
Thank you. I guess the other question is, you say that the rabies vaccine is mandated for employment because of the 100% fatality rate. It's my understanding that while flu vaccines are required for some employment, there are accommodations for those. That's correct, right?
So there are a number of other vaccines that might be required for certain types of employment. They might require hepatitis B vaccine, influenza. Those are some of the most common ones if you work in healthcare or in a laboratory. It really depends. There's no state law that is required.
One time?
Well, I think I'll take that question just in terms of explaining the requirements for schools. So there are a number of vaccines that require multiple doses in a series. Many times the children get all of the doses they need. For example, you mentioned hepatitis B, which is a 3-dose series, and the diphtheria, tetanus, and acellular pertussis vaccine has 4 or 5 doses. So they actually are getting multiple doses. Most of those vaccines, though, are not annual vaccines, which I think is what your point is. What about flu? We don't require flu for child
Right.
care and school entry, nor COVID yet. Most of the times where you're proving that you've met the vaccine requirements is at the kindergarten entry. And then again, there are some vaccines that you do need again, such as the Tdap vaccine, tetanus, diphtheria, and acellular pertussis, because whooping cough has been shown that your immunity wanes over time. And so you do need additional doses of that throughout your lifetime, potentially just to get your tetanus vaccine every 10 years, right? So you do need additional vaccines in order to attend 7th grade is usually where that's about happening again. And then the schools keep track of the kids' vaccination status. And if they're missing any, for example, at that 7th grade entry point, they're probably providing it, or as they go into middle school, providing that. So I think your point is correct that for school and childcare entry currently, the burden of to be able to enter is only happening once or 2 times throughout the child's course of school attendance because we're not requiring annual vaccines. There's not an annual vaccine requirement at this point. Does that help or answer your question?
So I have a couple for you. So you talked about TB, right? So that was how many times has the commissioner used its authority to require a citizen against their wills, I guess, is the real question. If someone volunteers for it, it's not an issue, even if it is a shall. But when someone chose not to volunteer to have the proper treatment for TB, that the commissioner forced that. Has that ever occurred? And if so, how many times?
We have ordered isolation and treatment for people with tuberculosis. It's very rare, but I actually have to go back and look how often this happens. I think we've written an order one time this year for tuberculosis, maybe a few, once a year or so. That happens out of the 20 or so tuberculosis cases that we get each year in New Hampshire. Oftentimes what happens is the individual doesn't understand the importance of the treatment. And when, we're trying to explain to them why it's so important for them to get treated. And then when you present them with an order, they're like, oh, you were serious that this is really important and I will do it. Again, no one has entered through that due process of actually ultimately refusing to be treated, for example.
Thank you. Relative to you mentioned rabies in certain circumstances for a process. So I guess my question is, again, going about mandates and conversations if I recall, under federal law, there was originally a thing about business mandates or mandates in general, especially in the healthcare field, having to be correlated as a direct threat to the job function. And the language they use is a direct threat. Does that apply to any of the mandates that we're currently looking at, or is it just a broad mandate that has no correlation to job function, but only a correlation to whether or not we want to get the vaccine or not?
Do you want to speak to this? I don't know if you looked into the direct threat language.
No.
Yeah. I don't know that I'm that familiar. I know that it has been incorporated and was in part of the discussions last year around it. I think part of that direct threat language has to do with, for example, in a healthcare setting, there's potential harm that would come to the patients that they're serving, which is the justification for requiring vaccination in those settings. But I don't think I can speak more to the federal law around that or wording.
Okay. And going back, you had said there were limited places in the law or rules that you apply a shall, but one of the ones you didn't talk about is the whole reason I filed HB 220, which was the vaccine requirements around foster families. And rather than create an exemption kind of situation where if you had a child who was immunocompromised, you would require that child to go to a vaccinated family, you created a broad rule that says if you want to be a foster parent, the entire family, including all the children in that family, must be vaccinated. Isn't that true?
That is not under my purview. That was under another agency within DHHS. Can you speak to that?
Thank you for the question. So our DCYF program is responsible for the administration of that rule, and so they're not here, unfortunately, today to speak to that specific foster parent rule. From what I understand, they felt it was important to ensure that foster parents and the children within those households that are caring for foster children receive the COVID vaccine, and that it is within their ability to do so. I'm sorry, they were not required to get the COVID vaccine. They're required to get influenza and other vaccines, but not the COVID vaccine. Sorry, I misspoke there. So I can certainly get more information and more. It can ask for DCYF to give you more information on the requirements for foster parents if that's what you would like.
I'm familiar with it. I just wanted to make sure we understand that there is at least one other place, and I don't know because where else it might be, but I know of at least one other place where it's a shall, it's in your rules, and it's one of the things this committee needs. Is the whole reason I filed 220 was I sat on jail car when that rule came through and opposed it then on religious grounds because there were no exemptions allowed within the rule. But it's just a broad-based shall for every foster family must get vaccinated. And I don't know where else. And I was hoping you were coming with answers where in your rules and laws you had shalls like that I know about, but I obviously don't know all of your rules. And I was hoping you were coming prepared to answer them.
That you've read the materials as part of the registration process. So that's how most organizations are doing that. That's how our state-run vaccination clinics operated as well. And, many of the pharmacies and healthcare organizations that have registration portals for vaccination appointments will ask you to look at these documents as part of the registration before you go ahead and schedule.
Great. Just a follow-up question to that because of your answer. So relative to that, we just heard from the Attorney General's office that consent needs to be given freely and without threat. How do you get around the people who don't want to take the vaccine but have their livelihoods being threatened and being forced to take in the vaccine? They have to make the decision between, do I keep a house over my head and food on my table, or do I get the shot? How do you define that, and how do you make sure that the person's giving a free and informed consent that's voluntary and not coerced?
So I think that's part of the issues that you all are addressing here. I don't have an answer to that question for you.
So I guess my question is around the ethics of it. So again, my question is around is that is it ethically correct for the state or a doctor to give a shot that's being coerced by an employer, under the threat of keeping a house over my head and food on my table for my children? Is that ethically correct? Is that something we should be looking into? Is that something that, just as a straight ethics issue that should be addressed within your agency?
Yeah, I don't have an answer for you to that question. I mean, there's laws and rules and regulations that come forward that require certain things to happen, and then you have to interpret those within the context of other laws and rules and regulations that exist. But I'm not the one administering the vaccine, right?
I'm sorry, doesn't the vaccine program fall within your agency that the state's running?
Sorry, I am not administering the vaccine. So I personally am not a vaccine administrator. I'm not a healthcare provider. I'm an epidemiologist and public health official, and we make our role at the health department is to make the vaccines available to the public who want to get vaccinated. Why someone is choosing to get vaccinated is up to that individual, right? Whatever constraints they have upon them as a person informs their decision making, but I'm not engaged in that process of it. I just make the vaccine available to them if they want it.
Thank you. And I will say that medical providers are overseen by the Office of Professional Licensure, the Board of Medicine, the Board of Nursing, those who are responsible for the administration of the vaccination. They have their own laws and regulations that they must follow. That's not under the purview of the Department of Health and Human Services. That's under the Office of Professional Licensure. But certainly we would expect and hope that all individuals are ethically receiving a vaccination. But it would be, if there are complaints or anything like that related to that type of coercion you're speaking of, that would go to the Office of Professional Licensure for their review.
I guess the reason I was asking, because you were saying you were running licensing clinics. DHHS is running licensing clinics. I'm assuming you're responsible for everything that occurs within that clinic if you're running it. And so I'm just concerned that as a state, we're not taking on a liability because we're not asking the right questions about whether it's freely given consent or is it forced or coerced consent by an employer to keep your job.
Thank you. So at the vaccination clinics, the individuals, no one is being forced to take a vaccine. Everyone who comes to those has presented saying that they want to receive the vaccine, and they're there freely on their own, own accord. We're not requiring anyone to get vaccinated, holding people down to vaccinate them. They're there. They've presented to get the vaccine because they have made the choice to get vaccinated for whatever reason.
I think I made my point. My point is about whether that consent is freely given or whether it's coerced or threatened, and whether or not a doctor has an ethical obligation to understand whether that's a forced or free consent, or is it because you're being threatened with your livelihood. That's all. Representative Goldie.
Thank you, Mr. Chair. And this, well, I guess would be addressed to your concern, to you, is we are already doing a number of these with flu vaccines, with businesses requiring other vaccinations or other immunizations for employment. Is that where we're going with this, or is it just specifically with the COVID vaccine?
Well, again, I think right now we're talking about vaccinations in general, and we're just seeing it. We're in unprecedented times, I think, where we're seeing mandates that are causing mass exodus to our workforce, right? We had, I think I read something like 26 fire departments were shut down in New York City because of firemen who refused to get vaccinations, and that now creates a different public safety issue that's going on. So I guess the concern is generally around, we've never seen these kind of mandates before, right, in an unprecedented fashion where people are being threatened with their jobs. And, other reasons, if someone goes into the nursing industry prior to this, they knew they had choices to make. And we know that there's a federal decision about mandates and direct threats, and nurses could choose to take or doctors could choose to go into parts of medical treatment that wouldn't have immune compromised people. So they don't have to worry about, if I don't want to get the vaccine, I'm not going to be around immune compromised people like cancer wards, right? So I'll go work in podiatry instead, right? Where it's not such a big issue, right? So they had those choices. Now they're not even being given those choices. And I think the question is around that, is that people their livelihoods are being threatened, and does that impact informed consent? Right, in the ability to give free and voluntary informed consent or not, is with their livelihoods being threatened like that now, because now you can't even go be a podiatrist without having the vaccine. So now you're giving no choice. So I think that's part of where we're having this conversation, is where does that go? How does that work? How does that intervention work, that medical intervention and immunization work in our society? And is informed consent now thrown out the window?
And if I just may respond briefly, that's where I'm going, is there's already requirements for other vaccines for these medical fields in place, and that's all I wanted to make was that comment.
Thank you.
Thank you.
Representative
Thank you. You've spoken to the consent part of informed consent. The discussion of people having to click through and say that they've read the information packet, and the fact that they don't ask a question when the person administering the vaccine says, do you have any questions? That doesn't seem like that's informed to me. When we're on our computers, we click through and say, yes, we accept the terms. I'd like to understand how the department views an informed patient and what kind of information should be available and ethically should make sure that people are truly informed about. I don't know if you want to speak to this at all, but so the process that we are using is pretty standard process of providing the information to the individual who is saying that they have read it and agreed to it. So I think the responsibility is on them. For people who don't have internet access or whatnot, they have those documents are provided to them. In fact, they're often provided anyhow, routinely to people when they're getting their vaccination. They have that information presented to them, and so if they have any questions about it, there's ample opportunity to ask questions if you have any concerns about getting the vaccine. Obviously, the people who are signing up to get vaccinated are people who have already, made the choice that they don't have questions or concerns. They've had those answered and they want to get vaccinated. I'm just trying to wrap my head around how these novel vaccines are treated differently than other novel treatments, other biologics, other procedures, and why there's more information and more discussion of that information needed for other interventions. Because we're looking not just at vaccines, we're looking at medical interventions more broadly. Why is there a different standard of consent, of information?
I personally am not sure where there is a different standard in that. As I said, the process that we use is like processes used for other vaccinations when you sign up to get vaccinated. It's all based on a similar process that happens for influenza vaccine or other vaccines that you get. It's a standard process.
Okay, so your knowledge is simply limited to those vaccinations and not to broader medical practice.
For me personally, I can't speak to broader medical practice. I'm not a healthcare provider.
Thank you. Actually, and do you have any insight to that?
I was just going to say that typically for novel vaccinations, those that are under EUA, the federal government requires additional information to be provided to individuals who are receiving a vaccination that may not have received full authority to under the FDA. So there may be additional information that's required, but the process wouldn't necessarily change. It would just ensure that whatever additional information is necessary. And the EUA very, very well could require additional process. And in that situation, they'd be, medical practitioners would be required to follow that.
Okay, I'm just trying to understand how somebody with terminal cancer can be denied a therapy because they didn't go through all the process for information, yet we don't have that standard here. So that's something that's probably better to ask of somebody else. I'm just trying to understand this. Thank you.
Any further questions for Ms. Daly? Thank you for coming. I appreciate it.
Thank you.
Next up is who, Erica? Representative Leon.
Next up is Chris Bond with the Department of Education.
Good morning, Chris Bond, New Hampshire Department of Education. So I think I mostly am here to take questions, but I can speak briefly to the questions that the committee posed. In terms of shall or shall not for medical interventions such as masks and vaccines, I'm not aware of any shall or shall nots as to masks or vaccines. Vaccines, of course, are addressed broadly in RSA 141C, which Health and Human Services spoke to. Masks, it's the department's interpretation that the state board, in delegating authority to local school boards to have health and safety policies, have effectively delegated the mask issue to localities, and there's no reference in the statutes that I'm aware of to masks. But there are a few areas where there are, and again, to echo what others have said already, there's no definition of medical intervention in any of the RSAs relating to the Department of Education that I'm aware of. There are a few instances where there's shalls and mays for what might be thought of as medical intervention, so I can just lay a few of those out. For example, RSA 240-A says that school nurses shall be permitted to administer oxygen to a pupil in a medical emergency without parental permission. RSA 200:42 provides that pupils can possess and may possess and self-administer EpiPens or epinephrine auto-injector pens. Similarly, RSA 244A requires that schools designate certain personnel to have anaphylaxis training, including the administration of an EpiPen in an emergency basis. RSA 246 provides that pupils may possess and self-administer asthma inhalers. But there has to be, my understanding is there has to be a plan on file with the school approved by the parents for that. RSA 254 says that school boards may authorize their school nurse to maintain a supply of bronchodilators, spacers, or nebulizers for use in an emergency situation. And RSA 255 provides that a parent may put written permission on file with the school for someone other than a nurse to administer a nebulizer or bronchodilator or spacer in an emergency situation. RSA 200:40 requires schools to develop written policies for immediate and adequate emergency care. So to the extent that any of those items might be considered medical interventions, I wanted to bring those to the committee's attention. And then let me see if I had. Yeah, so I think that was all the examples that that I was able to find of something that I thought might be responsive, but I'm happy to take any questions.
Thank you very much. Thank you for getting prepared with the places. Anybody on the committee have a question for Chris, Department of Education? I guess I just want to be clear. So the Department of Education's policy regarding masking is that it's up to local school boards to make a determination based on their public health policies.
Yeah, that's correct. So let me see. I just think I might be able to find a reference in our administrative rules that will be helpful. Under RSA 21N, the State Board of Education is empowered to create administrative rules for the operation of public schools. And in doing that, they've enacted the Ed 300 rules, which include Ed 303.01, which says that each school board shall provide that all school building and other learning environments be maintained in a manner consistent with standards of health and safety. Ed 306.04, which says that in accordance with Ed 303.01, referenced above, the local school board shall adopt and implement written policies and procedures relative to promoting school safety, wellness, and meeting the physical health needs of students. Ed 306.04D states that the policy relative to promoting school safety shall require school administrators to implement procedures which relate to safe practices. So the department has interpreted those delegations by the state board to mean that the decision on whether to have a mask policy is properly within the purview of the local school board.
Thank you. And a follow up to that, other than what's in RSA 141C regarding communicable diseases and school attendance, there's no rules or laws that you're familiar with other than that chapter of law relative to vaccination requirements for school attendance.
That's correct. My understanding is that the vaccination requirements are addressed in 141C 20A with the opt-out policies that are part of that statute, but I don't know of any other area where that's addressed.
Thank you. Representative Leon?
Thank you. This might be a bit too much of a clarifying question. Would it be possible for a local school board to require vaccinations beyond the public health requirements?
No, the department has taken the position that RSA 141C leaves that authority in the legislature, except to the extent that it's been delegated to the Commissioner of Health and Human Services, where there is a provision to add. And the department has taken the step of issuing a technical advisory to schools, I believe it was dated June 7th, where we specifically told schools may not add to the list of required vaccinations because that process for deciding what is a required vaccination is governed by 141C exclusively. So, and the department takes the position that that applies to non-public schools as well as public schools, because non-public schools that are approved by the Department of Education for compulsory attendance law purposes have to comply with the Ed 400 rules, which incorporate 141C.
Thank you.
You're welcome.
Barbara, are you all set? Representative Shaw? Okay, I guess she's all set.
Almost set.
I think she's looking something up. I guess I'll ask a generic question here, and that's relative to we've seen at the lately what's going on with school boards, right, and various activities around that. Are there any laws or anything that you can think of that the legislature should look at that deal with some of these things like masking that's being rallied about at school boards? Is there any place that we should be considering a law to ease these kind of tensions so they don't occur? Do you have any kind of input in that area?
I mean, that is a broad question to the extent that it touches on policy. I know the commissioner thinks it's important that parent input be part of decisions on masking. So, I mean, I think it's the department's understanding that those decisions are right now, based on the current structure, placed with the localities. So, I mean, in terms of resolving the tensions, I suppose it resolves the tension in one way if the legislature were to decide, well, we're going to make a masking policy protocol or put guardrails on those. I suppose that limits the tension, and to the extent that that takes that policy decision out of the hands of local officials where a lot of those clashes are happening. But I don't know if that might just move the tension to a different level. But that again, that's not, I don't know that that's a question that I'm qualified to weigh in on. I would just say that the commissioner feels very strongly that parents should have a role and a say in whether there's masking policies that apply to their children and how those are applied.
Thank you. Anybody else?
Thank you. I will ask one more. I apologize.
No,
I
no,
used to be a device and diagnostic analyst, so this is my wheelhouse. Does the department have any policies on the diagnostics and how students test to return, or is that all simply left to the Department of Public Health?
We have not gotten very involved in that. We have generally stayed away from testing as deferring to public health, with the exception of we have been very clear to schools that any testing that is done should have parental consent for it. We've also been very clear to schools that under their obligations to comply with FERPA, which is the federal student privacy law, any medical information they collect from students is a educational record under that statute, and they need to be very careful that they're maintaining those records with the appropriate level of privacy. But other than that, other than the privacy issue and parental consent, we have not had any input that I'm aware of into how the testing regimes are working out.
Thank you.
Thank you. Anything else for the Department of Education? Not seeing anything. Thank you, Chris, for coming. Very
Thank
much.
you very much.
Appreciate it.
Thank you.
Who's up next, Erica?
Up next is Cordell Johnston from the New Hampshire Municipal Association.
Let me get myself settled here. Good morning. I'm Cordell Johnston, representing the New Hampshire Municipal Association. And I'm here because I was invited, and I don't really have a whole lot to add. I'm happy to answer questions. At the municipal level, and I should say, I don't have a definition of medical intervention. But at the municipal level, the only examples that I can think of that I think that I would identify as medical interventions would be in some kind of emergency context. A couple of people have mentioned involuntary admissions, which would be which the police department might be involved in. Chairman Lang mentioned Narcan administered in an overdose situation, and that would be typically EMTs or perhaps the police department, but again, emergency responders. And I can imagine there probably are other emergency situations where someone might be administering some kind of sedative or pain reliever for, extreme, if an accident victim is in extreme pain. But those are the things I can think of, and I don't really know much about those. I know that representatives of the Police Chiefs Association and the Fire Chiefs Association have been invited, so they probably can speak better than I can. And the only other thing that I can think of that might be considered medical intervention would be drug testing. which private employers, I believe, I'm not an expert on this, but I believe that private employers are more or less unrestricted in their ability to require drug testing for their employees. Governmental entities are subject to a lot more restriction because if you're actually testing someone for drugs, and if that's being done by a local government or a state government, that I think is considered to be a search or seizure, and it's subject to the unreasonable search or seizure provision of the Fourth Amendment. And that's why I believe municipalities cannot routinely require their employees to undergo a drug test. There is an exception for CDL drivers and I think maybe a few other limited exceptions. And as I understand it, the courts have indicated that because of, there's a balancing test, and if you're testing someone who's driving a highway truck for the town, the safety importance outweighs the unreasonable search or seizure concern. But that's the only other instance that I can think of. And as I say, other than that, you're talking about emergency situations involving emergency responders. As far as municipalities as employers, there's been obviously employers requiring their employees to be vaccinated right now is a big issue. And I think I would view municipal employers in the same light as private employers. As far as I know, there are no municipal employers that have required vaccines for any of their employees. And I don't know, and I wouldn't necessarily know if there were, but as far as I know, they're not requiring that. And that's, as I say, that's about all I have to say. I'd be happy to try to answer questions.
Any questions from the committee? I'll ask a couple. So this is also about what we could possibly do where there's causing tension between municipalities and the state, and how to manage that a little bit better relative to these mandates that are going around. Is there anywhere you can speak of for your members that you think there should be some clarification or some cleanup in any statute that is relative to this medical intervention or immunizations that would help municipalities?
I don't think so. I mean, as I said, it's municipalities. I mean, whether it's COVID or something else, as far as I know, municipalities have not traditionally required immunizations or wanted to. I think on the assumption that immunizations generally for the worst diseases generally occur when you're 4, 5, 6 years old, and so when you're at the level of a municipality hiring someone as an employee, it really is not an issue. And certainly going beyond the employee context and trying to require anyone else to be immunized, I think would be pretty far out of bounds. So our members are not asking for any kind of legislation or clarification as far as I know.
Thank you. And regarding the drug testing you were talking about in certain circumstances, that's usually relative to the federal motor carrier law requirements. So trucks over a certain size, that kind of thing. And that's why they're required, is because they have to have a CDL license as compared to just a regular driver's license.
That's my understanding, yeah.
Thank you.
Thank you. I just would like to ask a clarifying question. It sounds that you would not support any municipality that tried to put on their own vaccine requirement or other requirements beyond that of public health. So,
We would not, sorry, I didn't quite,
Well, we did see with masks, which are a removable intervention. So we saw that some towns that put those into place. You don't see any expectation that any towns or cities would try and create their own vaccine requirement for citizens or anybody else within the bounds.
I mean, you know, I hate to say I can't imagine something because I can imagine almost anything. But if you're talking about a municipality requiring citizens to be vaccinated, I almost can't imagine that. I really don't think, you know, imposing, you know, the city of Concord imposing a requirement that everyone in Concord be immunized. No, I don't think so.
Thank you. We're just trying to beat around these edges and make sure that we have clean edges. Thank you very much.
So again, I think I don't remember the RSA, but there's an RSA relative to, they have a general welfare clause as to what cities can pass and do. And we had a bill last year to deal with that, to try to clean that up just, I think, for this reason. So I guess the question is it possible under that RSA, which I can't remember the number of it, but I'm sure you know it, that uses that general welfare clause of the citizens, would it be possible for them under current state law to create a broad community vaccine requirement?
Given
HB 220 as well.
Just to be clear, if for a town, that would be RSA 147.1. For a city, it would be RSA 4717, paragraph something. So would it be possible under those statutes for a city or town to institute an immunization requirement for citizens? Maybe. I mean, the language is pretty broad, so it's hard to say. Yeah, all I can say is maybe. It depends on how you interpret it. Again, whether the idea that any municipality would actually try to do that, I think that's very hard to imagine.
So the specific sentence, just so everyone's clear, is under for cities anyway, is 4717, and it's section 15, and there's a sentence in there. It says they may make any other bylaws or regulations which they seem to be for the well-being of the city. And I guess that's my concern, is that sentence, does that sentence give broad latitude, or would that be in conflict, do you think, with HB 220 that says government can't mandate immunizations?
Well, HB 220, as I read it, doesn't say you can't mandate immunizations. It says you can't require them as a condition to receiving a public benefit or whatever. But as I said, you know, the language is pretty vague, so someone could read that and say, yeah, that allows us to do whatever we want. And therefore we're going to mandate immunizations for everybody. I really don't think anyone's going to do that. And I don't think that I suppose if a city or town tried to do that, that might be the time when you would say, we need legislation to clarify that you can't do that. And I mean, and I haven't looked at all of these bills, they're not all available yet, but maybe there's one in there that says that no municipality can require that its citizens be immunized. And that certainly would, because that's more specific, that would preempt any effort to try to do that either under 4717 or under 147.1.
Thank you.
Okay.
Anything else for Cordell? Cordell, thank you very much for coming. Appreciate it.
Thank you.
Next up, Erica.
Next up is Barrett Christina from the New Hampshire School Board Association.
Good morning, Chairman Lag, members of the committee, Barra Christina from the New Hampshire School Boards Association. I appreciate Representative Leon you calling on the department before you called on me, because my testimony is essentially similar to what Attorney Bond from the Department of Education testified to a few minutes ago. I brought with me copies of the same statutes in the RSA 200 series that Attorney Bond referenced: school health services, school physician, physical examination of pupils, so on and so forth, medical examination of school personnel, school bus operators, as you referenced to Representative Lang. The pertinent statute, RSA 141 C20, I believe it is, to the specific questions that were asked to prepare for our testimony about support of shall not for medical interventions such as masks, vaccines, and other procedures. NHSBA has advised our members since the pandemic to follow the advice and recommendations both from Governor Sununu and Commissioner Edelblu that mask requirements or mask mandates would be a local decision. One of the bedrock principles NHSBA advocates for is local decision-making of local educational matters. So we did not tell our members to implement mask mandates. We did not tell our members not to implement mask mandates. We said, listen to your parents, listen to the health experts, and make a decision on what's best for your local community. Relative to the definition of medical intervention, I think that's been covered significantly from some of the other people that have testified. I don't have a definition of that. What I can tell you, though, is that through the series of statutes in the RSA 200 series, as well as Department of Education rule, I believe it's 311 and 312, which talk about some school health services. The only time there isn't any necessarily per se informed consent would be in a first aid situation with a student. You know, a kid falls off the jungle gym or trips and falls and they have to, bandage up his knee or whatever it might be. But all the other aspects about nebulizers and insulin and things of that nature, they or medication during the school day, they all require some level of parental consent, a note from the doctor, parents signing off on it, parents requesting that the inhaler or the insulin be provided at school or stored at school, a note from the doctor saying how often, Johnny or Susie needs this medicine or needs the insulin or signs to look out for. So within the school context, there's no uninformed consent short of an emergency situation where a student requires, essential first aid. One point that I do want to just clarify, I believe Representative Lang, you asked about rules relative to immunizations are under RSA 141 C20C. There is a Department of Education rule. It's ED 311, and the only thing that this rule does is basically restate the statute. A parent or legal guardian shall have a child immunized against certain diseases as determined in rules HEP. I presume that's Health and Human Services. Immunization requirements adopted by Commissioner of Department of Health and Human Services. A child shall be exempt from immunization in accordance with RSA 141 C20C. That's the religious exemption, and the if the vaccine would cause a medical harm to the individual, and you get a note from a doctor from that. A child is exempt from immunizations. A child who is exempt from immunizations in accordance with paragraph B shall not attend school during an outbreak of a communicable disease. If a child is not immunized, does not have a religious or medical exemption, or is unable to provide evidence of acceptable immunization for condition of enrollment, he or she shall not be admitted to school. That restates what the statute basically states anyway. But I just wanted to bring to your attention that there is a rule that speaks, Department of Education rule, that does speak to the immunization requirements. The rule following that, 311.02, medication during the school day, again, very prescriptive, requires parental consent, to bring in a note from the doctor, things of that nature. So I don't think I have anything new to add, but I'm happy to answer any questions that the committee may have.
Okay. Anybody from the committee? I'm going to have one, of course. Because you brought up the whole area around medical exemptions for schools. Given that the Surgeon General has said that they want to look at religious exemptions again and whether or not they're being abused. question I have is it a proper role for schools to decide how religious an individual person is and whether or not they're entitled to an exemption? Is that something we should tighten up or clean up, or is that just so broad that it leaves you exposed?
Yeah, thank you for the question, Representative. I did see you have a bill, and I saw some of the language about broadening. I believe your bill says religious exemption, medical note, or conscientious objector. I believe that was the phrase that's being used. We don't have a position, we meaning NHSBA doesn't have a position on vaccines just in and of themselves, especially as it relates to COVID. We have not been asked whether or not we meaning school districts can mandate employers or students to be vaccinated to either attend school or to continue employment. We just haven't gotten that question. So I don't want to give a firm answer to your question just yet, Representative. I've seen the bill. I don't know if NHSBA will be testifying on it when we get into the legislative session, but we will certainly be tracking it. And I would want to do more research on perhaps what other states have on their laws relative to immunizations and opt-outs and parental consent and things of that nature before I offer a formal position on behalf of NHSBA.
Right, I guess the question wasn't about the bill. It was just merely about the fact that is it better to clarify things like medical exemptions and religious exemptions so that the school's not exposed to,
Right.
Number one, you're requiring a parent to open up a medical chart to prove a medical exemption, right? So now you have to read people's medical charts. And the second one being a religious exemption, especially with the Surgeon General pointing at abuse, now you have to go back and see whether or not it's a valid religious
Right,
exemption, whether it's a
right.
sincerely held belief. And is that a role that we really want our schools to be in, to do those kind of things, is read medical charts and determine whether or not a person's religious enough to be entitled to a religious exemption?
Sure. Thank you for the question, Representative. In terms of religious exemption, it's not a school board's role to determine whether or not you are being sincere in your religious beliefs or your statement of, religious exemption. Relative to the medical record aspect, school districts do not want to receive medical information from students, but unfortunately sometimes we have to, whether or not that's a medically fragile student who is receiving some sort of special education services. This legislature recently passed a very significant law expanding protections for students who have concussion in youth sports. I forget that bill number from last year. And so there are certain circumstances in which the school district does need to get medical information from a medical provider. Concussion, special education services, 504 disability plans, where if a student needs to be out of school for a medical condition or a disability of some sort. So, I understand the question, but I guess the larger answer is that we already are doing that for very specific needs. So that may fall under, the need to look at a medical record relative to an immunization there's at least analogous responsibilities that school districts already have relative to an individual's medical information.
Thank you. Anybody else? Okay. Erica, did anybody else turn on pink cards?
Thank you very much.
No, there are no other pink cards.
Is there anybody, I will just make a statement that the fire and police will be coming tomorrow. I spoke with them and they, as you know, the trooper that died, his funeral and procession is today. And so they called and they said they would send somebody, but I told them they could just wait till tomorrow. There's no need to do that. So I do know the police will be coming in to speak in general about their rules and procedures and where there's intervention by either state law or by rules, Department of Safety rules of some sort. Is there anybody else that actually would like to testify or have a comment for the committee? Okay. Wow, we're done early. If there's nothing, committee members, any general discussion we want to have regarding the presentations that were made today, questions that were asked, and the answers that were given? Anything we think we want to look at tomorrow? We have the business industry and the medical industries coming in. We've invited the BIA, the Retail Association, the Manufacturers Association, and Hospitality Association on the business side. And we've also invited the New Hampshire Medical Society, New Hampshire Hospital Association, the Board of Medicine, and the Board of Pharmacy to come in and speak tomorrow and answer questions tomorrow on these topics. We have a public input session for the general public scheduled for Monday the 8th at 9 a.m. in Reps Hall. I'll be adding a second one on Wednesday, the 10th, in the morning. I found out that the redistricting committee is going to meet that evening, and so it leaves Reps Hall open for us for the day. So I'm going to schedule a second one in case we need it, if we don't get to everybody who wants to testify on Monday, to give them the ability to come on Wednesday to testify as well. But given that, is there anything we want to discuss?
No, I just want to thank everyone that came today. I think it was very helpful to hear, and it was just interesting to hear that there was very limited in statute dealing with medical intervention.
I agree. Thank you. And I do appreciate everybody coming in and providing input. And again, if you want to provide written testimony, or if you go back to your offices and you realize, oh, I should have said, then feel free to email. You can either email me directly at my legislative email address, which is timothy.lang@leg.state.nh.us. And I'll make sure the committee gets copies of it. But I appreciate everybody coming. If there's nothing else to come before the